warranty. Did you guys hear that?
Yeah, she just said that she was recording.
Yeah, that's really weird. Have we not been the whole time? Am I breaking up on you guys? Are we? No? Okay. All right. That Zoom at 8:11 at night, I guess. Home warranty. Is the seller going to offer the home warranty? You know, a lot of home warranty companies will cover the seller while they have the home listed. We haven't seen the seller offering home warranties in the last couple of years, but as that pendulum swings back and we get closer and closer to a buyer's market, we very well may see some home warranties again. Then we have the listing price. Seller lists the property at a price of. As we mentioned earlier, you can fill in some of the blanks on the listing appointment before you go. But this is one of the blanks that needs to be blank when you meet with the seller. We can do a CMA. Aren't we going to do a CMA before we go anyway? But isn't everything going to change when we walk in the front door? I have no idea the condition of the home. Do you need a fresh coat of paint? Do you need a good clean? Does your carpet smell like dog? You know, I have no idea the condition of the home until I walk in the front door. So we can fill in as much as we can, but we do need to leave that listing price along with our commission blank until we actually have the discussion with the seller. And then we need to discuss on what terms would the sellers consider acceptable. I don't know many people that would say no to cash, but there might be some people that maybe the home doesn't qualify for FHA or VA. For example, if there's a lot of repairs needed, FHA, VA may not qualify. If it's not in a rural area, USDA isn't going to be an option. So what we're talking about here are things that they could consider and what the seller could or would consider. Here's our compensation. Again, these have got to be blank until we have the discussion with the seller, making sure that they understand we're negotiating these, particularly our fee. Seller agrees to pay the firm a total fee of X amount. The seller pays the listing firm. The listing firm shares their commission with whomever brings the buyer. So the first time we talk about commission here in provision 7 is the total amount of commission. What is the seller going to pay the listing firm? In just a minute, we're going to see the split between the listing firm and the selling firm. So is it going to be a percentage? Is it going to be a flat fee? We talked to the seller about when we've earned our commission. When we earn our commission and when we actually get paid are two different things sometimes, aren't they? We earn our commission when we bring that ready, willing, and able buyer to the seller. Ready, willing, and able buyer. When I see ready, willing, and able buyer, I always think of a three-legged stool. And when you have a three-legged stool, if one of those legs falls out, doesn't your stool fall down? Same thing with the buyer. We got to have all three of those legs. That's technically when we've earned our commission. We've provided them with a ready, they're ready to buy, willing, which means they want to, and able. They have the financing, they meet all the terms. Technically, you guys, that's when we've earned our commission. That's what the contract says. Is that when we get paid? Yeah, no. I hope that's not brand new information for you. You guys are new. I don't want to scare you. Things can happen. Things can happen. And like we said last night, our job, our duty doesn't end when the contract is signed. We keep going until we get it to closing. We see this thing through the end. Our listing agreement also has something called a protection period. If the firm sets out has not occurred, if we haven't sold the house or the property, and within X amount of days after expiration date, a negotiable blank, is it 14 days? Is it 14 months? Firm policy, and it's completely negotiable. What we're saying here is if within this amount of days from the expiration date, if the seller sells the house anyway, we still may be entitled to a commission. That protection period is protecting us. It's protecting our commission. Let's say, for example, guys, there's some shady sellers out there. Let's say, for example, you have a buyer that's interested and you know that they know, the seller knows that this thing is getting ready to expire tomorrow. Don't they have the name of the buyer? They have an offer. Don't they have the name of the buyer? Couldn't they call that buyer and say, withdraw your offer and bring me another one tomorrow? I don't have to pay commission. That would be a case where we could have a protection agreement to reserve our commission, because doesn't it stand to reason that buyer met that property through our marketing, our advertising? So we still could be entitled to a commission within so many days after expiration, after it expires. There's two caveats to this, though. There's two things that could stand in the way of us getting our commission during this protection period. In order for us to get paid a commission after it expires, we need to, I was going to find it here real quick. We need to provide, there it is. The names, there we go. We need to provide the names of the buyers that are interested. So this isn't just any old buyer. This is specifically Mr. and Mrs. Jones. You guys with me? This is somebody that came to my open house on Sunday and said, oh man, I want to buy this house, but we can't do anything till Thursday. And you know your listing agreement expires on Wednesday. We've got to provide the names. The second caveat, though, is if the seller enters into a listing agreement with another firm. If they expire with you today and they list with another firm tomorrow, we're out of luck. The new firm will prevail. But still, it's a chance, right? You've had this thing for 6 months and it expires. Don't you want a shot of getting a commission? And that's what that protection period is for. Again, you guys, the reasoning being is because it stands to reason this buyer learned about this property through your marketing, your advertising. And that's why we have this protection period. What do we think about this protection period? I see head bobs. I agree. Yeah.
It's a good idea for sure.
Definitely. Again, there's some shady buyers and sellers out there. So it's nice to know that NCAR and the Real Estate Commission, yeah, their main purpose is to protect the public, but guess what? They kind of got our backs in some cases as well. And that's why they offer us this protection period. Questions on that?
I have a question just about something you said earlier that somewhat relates to this, and I might be jumping ahead and let me know if I am, but it says the fee earned for the sell listing agreement, but you said that if a seller like didn't agree to pay, then you'd have to get it from the buyer.
That's right. That's right. So both of our, yeah. So what we'll see probably first of next week, Teresa, when we look at our buyer's agency agreement, is the similar verbiage about when we earn a fee. But when we're talking with buyers under the firm's commission, the buyer's agency agreement actually says that I will always ask the seller to pay me first. But if they can't or won't, then you're up. There's only two parties to the transaction, right? There's only two people that can pay me. So if the seller says, no, I'm not going to do it, who's left? And that's what our buyer agency agreement says.
Okay.
Let's see. Additional compensation. I know I don't have this highlighted, but it's worth mentioning. If you ever stand to make a bonus or rebate, some kind of thing of valuable consideration, more than the agreed upon commission. So you and the seller agree, you sell my house, I'll give you X amount. Whenever you stand to make a bonus or anything more than that, we've got to disclose that to our seller. Anytime we make more than the agreed upon commission. And again, thank you Forms Committee. They provide us with a form that we can use to disclose that bonus. I think we see this more with buyers bonuses, but it's also in the listing agreement too, just to let us know that we need to disclose. We've got to disclose that information. So we previously talked about the total fee that the firm expects to collect. Seller pays the listing firm shares their commission with whomever brings the buyer. So we know the seller's going to pay the firm X amount. Now we need to negotiate and share with the seller what the breakdown is of how much we're going to give the buyer. You know, my 0.5%, that was what the seller agreed to pay a buyer's agent, and that's where this came in. And one thing I want to make sure we see for sure, we got a couple of different options here. Is the firm willing to cooperate with the sub-agent? Is the firm willing to cooperate with a buyer's agent? So we have two different things that we need to discuss. I don't know anybody that's going to say, no, I don't want to work with a buyer's agent. We just need to tell the seller, when a buyer's agent brings us a buyer, this is how much of my commission I'm going to give with them. And same thing with sub-agents. Fred, I actually like your MLS in some ways better than Triad MLS. In Triad MLS, you just put in a commission. You say if you want buyer's agent only or seller sub-agent, and you just put a number. In Canopy and MLS, it says, how much are you willing to pay a seller sub-agent and how much are you willing to pay a buyer's agent? So it allows you in the MLS to break it down so you can share that cooperation with other agents. Be one thing I wish Triad would catch up on, but maybe in time. Comments on that? Sharing our commission and who we can share it with?
Does anybody else see the Stay Puft Marshmallow Man and the painting in the back wall?
Mine?
You talking about Julie's back wall?
Yeah,
Yeah, it's like, it looks abstract. I don't think it's it looks like some sort of abstract painting.
Yeah, but it does look like a Marshmallow Man or the Abominable Snowman. The longer you look at it, it's going to be different people. You know, that picture you have in the background.
Yeah. I'm going to have to go painting shopping now. Thanks, guys.
Yeah, I don't think you had that when last year. You must have just.
I changed it up. That's what I get. Have to go back to what we know. What I have last year, sunflowers. Maybe that's what I'll get.
yeah. I mean, now that I'm looking at it, it almost looks like the Pillsbury Doughboy.
Oh my. All right. So how about we look at the listing agreement? How about that?
Okay.
I promise you, you won't be tested on my picture. I promise. Okay. Our listing agreement is a bilateral contract, which means it's a two-way street. In contract world, lateral means side. So a bilateral contract says both sides have to perform. Both sides have duties and obligations to each other. So our listing agreement has to spell out the firm's duties, what duty the firm owes the sellers. It's going to spell out in just a second the seller's duties to the firm. So in looking at our firm's duties, we're reminded of our code of ethics. If you're using this form, you're a realtor. So we're reminded of our code of ethics. And the firm's duties, we need to make, that's our job, isn't it? Our best efforts to find a buyer. Do what we can to find that ready, willing, and able buyer for the seller. We have a duty to disclose material terms of the offer. Remember, we have to present all offers to the seller. Even if it's a low ball, just downright insulting, something that's just going to make your seller mad. Do I still have to present it? You better believe it. Because we present what offers? All of them. Every single one of them. And that's what we're sharing with the seller. Disclosure of material facts. We always have a duty to disclose those material facts. With sellers, we may be asked about other professional services. Again, I think this is something that we see more in our buyer's agency agreement. Working with buyers, but we could have sellers ask for, surveyors, home inspectors, structural engineers, if they need to fix something, repair something before we list it. What we're saying in this paragraph, you guys, is like, look, if you ask me for suggestions for another professional service, I can offer you a couple to choose from. I formed relationships I know home inspectors, structural engineers, all that. But I'm in no way liable for these other professional services. So if the home inspector comes in and messes up, that's not on me. All I'm doing is recommending a name. I mean, if you think about it, our only other option is to send them to Google and let them find something on their own. So wouldn't they rather get a referral recommendation from me, somebody I've worked with in the past, versus trying to find one on their own? Providing agreement to the listing services, that's submitting the listing to the MLS. When you put a listing in MLS, it all starts in the MLS. And when you put that listing in MLS, it is fed to thousands of websites. And I'm not kidding when I say that. It all starts in the MLS and it goes through the IDX, the Internet Data Exchange, and it is fed to thousands. Every place you can see a home for sale, it all starts in the MLS. So we agree to have that marketing, have that exposure, that online exposure. Here's our non-discrimination clause. I got it highlighted here for you guys, but if we're looking at the regular form, we can see it's bold, it's all caps. It's important that the seller understands that we're not going to discriminate based with the regard of the protected classes. We also have an ethical duty not to discriminate based on sexual orientation or gender identity. That's one of the musts of our listing agreement. Big red warning is addressing buyer letters to sellers. They're sometimes called heartstring letters. Buyers are submitting letters to the sellers, telling them why they should pick me, why my family would be good in this home. The concern with the buyer letters is that they could bump on fair housing. They could bump on that a little bit. So if you have a buyer sending a letter talking about, I can imagine my family sitting around the living room on Christmas morning. Didn't you just hit family or fair housing twice? You talked about familial status and religion. And that's the concern with the buyer letters to sellers, is that there could be violations. There's no rules out there on this yet. I think these are going away, especially as the market's kind of simmering down a little bit. I know some agents won't present them to their sellers. They've had this conversation. I know others will. So it's a kind of a case by case, but it's absolutely worth having the discussion with the seller and letting them know the potential harm that could come out of this letter. As a buyer's agent, I've only submitted one love letter on behalf of my buyers, and they were talking about how much their dogs would enjoy the backyard. So we weren't talking about people. I didn't feel like it was, they even submitted a picture of their dogs. Don't let them submit a picture of the people. Right now we know a whole lot more. So yeah, the whole thing was about dogs, and that was the only way I would agree to do it. It wasn't even a multiple offer situation. They just had a friend that did it and they wanted to do it too. So obviously they got the house, but I went in it with, with caution. And that's what this is doing, is warning us about that. Questions so far? Looks like we're ready for our last break. So let's take 10. Let's see. Yeah, we'll finish it up for the night.
Sorry about my humor at times. I'm just trying to stay awake and keep everybody entertained.
What do you?
Are
I'm
you talking
sorry.
about that picture?
Oh,
Just the picture and other stuff. I'm just trying to keep myself
Okay.
stimulated.
Don't
as far
worry
as
about the picture. I was thinking the same thing myself about the picture. So
I just know I need a new picture now. So, you know.
it's fine. It's just, yeah. But I mean, we're looking at it for 5 hours each night.
I
So
get it. I get it. Yeah, you guys got to like it too. I don't see it.
In the picture's defense, you're pacing around back there, so you're bringing attention to the back wall, and we can't help but to follow you and to see what's behind you.
The picture. Gotcha. Gotcha. You know, any constructive feedback is always welcome. So we'll take it.
I'm not saying there's anything wrong with it. I
No.
was wondering if
Just-
anybody else saw what I was seeing.
oh yeah.
So, all right, let's see. It looks like we're coming back. And still on our listing agreement. This sucker's 13 pages now. Buyer's agency agreement isn't as long, but still. So we talked about the firm's duties, the things that the firm owes the seller. Now we're going to talk about how we're going to market the property. Commencement of marketing. We need an actual date that is going to go active in MLS. Maybe it's going to be the effective date being the date that we sign the agreement. That's going to be awful tough to do, isn't it, though? We signed the agreement today because now I got to get my photographer out here. I got to get my measuring guy out here, or I got to get my stuff out here to do it. So we need to make sure we have a very reasonable, understandable marketing date, understanding that it's going to be really tough to get this thing in MLS the day that we sign this agreement. So knowing your services that you're going to use, you know, are you going to go measure it? Are you going to take pictures? Are you going to have somebody else do it? And having setting that reasonable expectation. Marketing. Oops. Marketing can go one of two ways. And I'm going to skip ahead just for a second. Well, no, here it is. We are told here, marketing can either be public marketing, which means we're going to put it in MLS, or we're going to do office exclusive. Office exclusive means we're only going to make it available to those agents in our office, not our firm, those agents in our office. And if something, as we'll see in a second, is office exclusive, that means we cannot talk about it outside of these four walls. We can't put it out there to anybody else other than us. It's an in-house or in-office, I should say, transaction only. So we're told to select one or the other, but not both. And then we have, if we're going to go the public marketing route, we're going to check this box. Some things to know with public marketing, most MLSs now allow a coming soon. So if you're going to do coming soon advertising, you know, the thing with coming soon, we can promote it, we can advertise it, we can put it out there. We can't show it. It's not available for showings yet. It's not active yet. It's kind of the building hype, trying to get people excited about it. And again, you guys, this is a conversation we need to have with sellers, because it's not that we can't show it yet, it's that nobody can show it yet. And there have been cases where buyers roll up to the house, knock on the front door and say, I see your house is for sale. Can I come in and see it? So first off, we need to let the sellers know, no, they can't when it's in coming soon status. The second, remind sellers that they need to be safe. And it may not be safe to let a total stranger into your house that says they're interested. You guys with me? So many things wrong with that. But just prepare them if you're going to do coming soon. I think try it MLS. They just changed it. It used to be you could be coming soon for 21 days. And I think they just changed it to 12 or 14, something like that. 7, no, maybe it's 7. That's what it is, 7. So again, you're just building hype, building awareness. Is the seller going to authorize us to put signs in the yard? Not all sellers want their neighbors to know that they're moving. Not all sellers want a for sale sign. Is the seller going to authorize us to do open houses? Is the seller going to offer us to advertise other than the internet? Are we going to do print media or and I don't know what else is left if it's not internet, but y'all remember like the real estate book? That thing got smaller and smaller and smaller over the years, right? So maybe something like that. And then we do need authorization to put it online. Again, we're going to talk about safety in just a bit. Seller safety are so important. Making sure that they understand that we're getting ready to put their home on the internet, and making sure they understand, you know, again, we're going to encourage them to put away valuables, personal effects anyway, but particularly before we show up to take pictures, we certainly don't want people kind of casing the joint out, you know, and seeing something that looks nice and then pretending to be a buyer to get in the home or going to the open house. So safety always first. Then if we go office exclusive, that's our other option. So we're either going to go public marketing or office exclusive. Firm is prohibited from marketing the property publicly, including any methods listed above. If at a later date the property shall be public marketing, this agreement must be amended. So if you're going to go office exclusive, again, you just only promote it within your four walls. You can't talk about it with anybody. If you talk about it with anybody, then now you've opened it up to the public. But maybe you have a listing coming on. Maybe you work with an investor and you have a listing coming on and you know this would be a good fit for your investor. That may be a reason, you know, but the seller needs to understand that if we keep it office exclusive, we may not get them the highest. I mean, we don't know. We don't know what the highest offer, but sometimes for the seller, I think for the seller, sometimes it comes down to time versus money. And if they want to sell fast and you got a interested investor, that may be an option here. If you do go office exclusive, we still need to put it in MLS when it closes, just for comp purposes. That's what this blue note is saying. We still want to put it in our listing services. Does the seller authorize the firm to put a lockbox or a key box on the property? Again, there's safety issues. We need to make sure the seller's aware. Super boxes and Sentry locks tend to be more secure. The problem with combos is once an agent learns the combo, they always know the combo. So seller safety, worth having the conversation. Seller acknowledges and understands that while the marketing services selected above will facilitate the showing, there are risks associated with allowing access and disseminating information about the property that are not within reasonable control of the firm, but including but not limited to unauthorized use of lock boxes, control of visitors during or after showings or in an open house. There's been numerous occasions where buyers go in, buyers agents go in, and they're caught on camera doing things in the seller's homes that they probably shouldn't be doing. I've heard a couple of times now over the years about buyers going in the home and letting the kids jump up and down on the bed. Sellers catch that on camera and they're usually not happy. If we find out that buyers have been going through, rummaging through dresser drawers or anything like that, you know, as a buyer's agent, I keep my buyers corralled. I don't let them run amok through the home. I stay with them so I know what they're doing. You may want to kind of control your showings. Always remember, always remind your buyers, it's still the seller's home. It's not your home yet. So just because they may be under contract doesn't give them the right to show up whenever they want to. Inappropriate use of information about the property on the internet, information about the property placed on the internet, even after it's expired. Remember, I just said you put it in MLS and MLS feeds it out to like thousands of websites. when it goes under contract, when it expires, when it closes, they may not pick that up as quickly. So you may have a listing, several months from now. Every once in a while, you have a buyer that bought and they're still getting calls because 123 Main Street is still showing active on this random website. So, I have zero control out of anything outside of MLS. And that's what this seller acknowledgement's saying. So we have no control over the information. Seller agrees that seller is solely responsible for securing all valuables, cash, jewelry, firearms, medications, tools, other items of personal during the term of this agreement. Again, it's absolutely worth having the conversation with the seller about their safety and their stuff. Then we got this big red warning, and this is a question that comes up a lot. Again, need to have the conversation with the seller. This is such a sign of the times. Maybe a crime under federal and state law to listen to or record an oral communication through the use of electronic or other devices without the consent of a party communicate. If there is video audio surveillance, the seller is advised that no audio may be turned on during the showings and that the placement of video should not violate a visitor's reasonable expectation of privacy. There will be cameras on the home. Y'all, it's 2023. Why don't you conduct your life as if we're on camera video? Because you know what? There's a really good chance that we are. So video, ring doorbells, all that, absolutely. What the seller can't have is audio. With that being said, I still have a conversation with my buyers before we start looking at properties. I say something like the sellers shouldn't have audio, but in the event they do, I need you to be careful. And what I want them to be careful about is I don't want them giving away their negotiation power. I don't care if my buyer walks in the front door and goes, oh God, that carpet's tacky. I don't care. That makes no difference to me. What I don't want is my buyer walking in the front door going, oh, this is it. This is the one I've been looking for my whole life. I will do anything for this house. Because when the seller's sitting there listening to that, what did they just hear? Cha-ching, cha-ching, cha-ching. So have that conversation, even though the listing agreement says so, have that conversation with your buyers to help protect them. Thoughts on that?
Thoughts are just so deep with that. Yet, how do you tell the people to turn off their surveillance, but yet you've got strangers coming in your house? You know what I mean?
I know. You can keep your video on. You can keep the video on. You just can't have audio. Shouldn't.
I'm glad you mentioned it. I've done a lot of buyer consults, and there's a warning on that side that says, that you're have a chance to be surveillance when you're viewing properties, but I never thought about the audio portion of it. So thank you for sharing that.
Oh, yeah. It's big. And you guys, it's one of these things that isn't going to get any easier as time goes on, right? Things are getting smarter and smarter and smarter. So the Real Estate Commission has an educators conference once a year. And it's actually coming up in a few weeks. We get to go to Raleigh. We're going to be in person for the first time in 3 years. I'm so excited. But yes, I'm so excited. But one thing that they always do at the educators conference each year is kind of give us a recap of the most common offenses, the most common violations from the year before. And last year at our conference, they shared with us that one of the biggest offenses, one of the biggest complaints they got were buyers and buyers agents stealing prescription medication, going into kitchen cabinets, maybe medicine cabinets. And a lot of these buyers and their agents were on tape. I mean, think about it. Where do people keep their prescription meds? Either in the medicine cabinet or the kitchen cabinet. Guys, think about that kitchen cabinet, even the medicine cabinet. Shouldn't buyers be encouraged to go through the things that are going to stay? Don't we want them to look in closets Don't we want them to look in kitchen cabinets? And we don't need them rummaging around through the desk or the dresser, right? But if it's going to stay, buyers should be encouraged to look in it. So tell your sellers, don't put your prescriptions in the kitchen cabinets. Don't put your prescriptions in the medicine cabinets, because the buyer opens the door and they go, oh, score, and now those prescription meds are gone. Yeah, I'm not kidding. I was showing a house once and my buyer and I walked in the bedroom and there were like 4 prescription bottles just chucked out on the bed. The bed was made, everything was nice, but they were just, it's like they took a bill and threw it on the bed, took a bill and threw it on the bed, took a pill and threw it on the bed. And then they just left them there. And my buyer was like, oh my. And I was like, yeah, we're going to skirt around that. We're not getting anywhere near that. You got to be careful. Your listing agents, we definitely need to have this conversation. And like I said earlier, sometimes buyers act as buyers to scope the place out. Sometimes buyers go to open houses to see what you got, to see if it's worth going back later and hitting you up. So don't show the people what you got. To Michael's point, you're getting ready to have a whole bunch of strangers in your home. Don't leave them temptation. And we've got to have these conversations with our sellers. What other thoughts on that do we have? There's a lot to think about, isn't there? That's why I love being familiar with the forms. I don't have to think about this stuff. The forms help me out. Earnest money, whether or not the firm does or does not maintain a trust account. Talking to the seller about earnest money, talking to the seller about what happens to the earnest money when we go under contract. Letting the seller know that if the buyer terminates within due diligence, they'll get that earnest money back. Letting the seller know that if the buyer terminates after due diligence, they're going to get it. Letting the seller know that if we terminate and that earnest money is in dispute, then the escrow agent can't release it without permission of both parties. And if both parties, if either party doesn't agree to release it, then those disputed funds are to be turned over to the clerk of courts. Let the two go downtown and hash it out. But the escrow agent has zero control over what happens to the earnest money. They're just acting as a safe holding ground, impartial holding ground between the parties. The seller has to make some representations. And again, we see a lot of these in our offer to purchase and contract. I'd say the listing agreement and the offer to purchase and contract, there's quite a bit in here that's just copy and paste. So when you're familiar with one, then it kind of gets you into both. So the seller's got to represent how long they've owned the property. Have they owned it for at least a year, less than a year? They don't yet own the property. The reason this matters, it might matter to the lender. It might matter for tax purposes. I know, for example, if you're going FHA, if your buyer's going FHA, the seller has had to own the property for 90 days before they can contract to sell. So if you have a flipper or an investor, that would be reason that we would need to know that. Make sure that we can contract. Whether or not the seller is or is not under bankruptcy or contemplating bankruptcy, we're kind of asking the hard question. I mean, presumably I just met these people and I'm already asking them, are you in bankruptcy? Are you in danger of bankruptcy? But it's stuff we need to know. I'd rather ask the hard questions up front than get stuck in a situation closer to time. So definitely ask the hard questions. Again, let the forms help you out. Is there a manufactured or a mobile home on the property? If so, the information on that. Here's for our owners association, if applicable. What are the dues? No, name, address, phone number, excuse me, website, how we get in touch with them. We're encouraged to provide the seller with receipts of sample forms, as we mentioned earlier. We're encouraged to provide the seller with a sample offer to purchase and contract. We're also encouraged to provide the seller with a sample professional services disclosure and election form. We can only check these boxes if you provide the seller with the sample forms. Makes sense, right? If you're not going to provide the sample forms, then don't check the boxes. Are they in a flood hazard? And if so, do they currently maintain flood hazard insurance? Here's our synthetic stucco. We said if it's ever been clad in synthetic stucco or EIFS, it will always be a material fact to the property, even if it's been replaced or repaired. Is there a termite bond on the property? If so, is it transferable? And then here's where we ask about all the liens. Which are outstanding liens? Your first deed of trust, lender name. Notice that says approximate balance. I'm not looking down to the penny. I'm just trying to get an idea. There's actually a place here for 1, 2, 3 outstanding leads, outstanding deeds of trust. As you're filling in, your seller's filling in all that information, you want to make sure as those approximate balances start adding up, this is a good way for us to learn early on if the seller's underwater or not, if they can afford to sell. We'll talk about short sales tomorrow night, but making sure that they can afford to sell, they're not in danger of foreclosure or something. But if these approximate balances start adding up and you know your probable sales price, we got to ask the hard questions up front so we can avoid situations later. Could you guys imagine 2 days before settlement, you call your seller and you say, I look forward to seeing you at the attorney's office. You need to bring a check for X amount. And the seller says, yeah, I don't have that kind of money. Did that just hurt you a little bit? That just hurts me a little bit. So have the hard conversations up front. Have the discussion with the sellers up front. Sellers current on all payments. They're not in default. There are not any liens secured against the property for taxes, for example. There's no judgments on the property. There's not anything that can violate the UCC, Uniform Commercial Code, is what regulates personal property. And if so, then we're going to specify any information that the seller needs to represent about 2 through 6. So remember, we've asked the seller to start gathering this stuff, start gathering their outstanding liens. And now we're going to fill this in as part of our agreement, just to make sure we're all on the same page. The property is or is not subject to a lease. Do we have a lease? Do we have a tenant in place? If so, is it managed by a property management company? Has the seller recently had an FHA appraisal? FHA appraisal stay with the property for 4 months. So if the seller's had an FHA appraisal, it's going to stick with it. So if the buyer's getting an FHA, they're going to rely on that one. Special assessments, maybe from an HOA, an owners association, may also refer to special assessments from the government. So maybe they're going to install street lighting or hook an entire neighborhood up to public sewer. Is there any kind of special assessment that's out there that the seller needs to disclose to the buyer? We know we hash out special assessments in our offer to purchase and contract, but right now the seller's just acknowledging, recognizing if they have any. Are there any fuel tanks on the property? If so, we're going to complete the following information. We've got a place for 2 tanks. It's either currently in use, currently not in use, it's owned or leased. Where is it and what's in it? We want the name and the contact information of the fuel vendor. We do that again for tank 2. They revamped this section both here and the offer to purchase and contract in the last forms update last year. Both, I don't know why, but prior to the revamp, fuel tanks that were talked about like on several different places. So one of the big changes they made to the forms last year was they kind of put fuel tanks all together for us. So that was helpful. That was a good change. Then we have seller's duties to the firm. Seller agrees to cooperate with the firm in the marketing and the sale of the property, including but not limited to. The seller needs to provide the firm with the seller disclosures unless exempt. So the seller agrees to cooperate with us in getting the RPOs, the MOG, the lead-based paint. Making the property available for showings, and this does include working and existing utilities at reasonable time and upon reasonable notice. It's awfully hard for me to sell your house if I can't get a buyer in the front door, right? If you never allow a showing, if you never allow anybody to see it. Now, let's be reasonable. You know, the seller calls you and says the whole entire house has come down with COVID. Can we have a few days? Well, yeah, absolutely. We're going to stop showings for a few days. Every once in a while, you get a seller that says they have like a newborn baby and nap time is 1 to 3. Can we work around that? Well, of course we can. You know, we can be reasonable. We can work with the seller. That's a big difference in never allowing a showing. The seller agrees to provide the form with, here's our HOA documents, our covenant, provide the firm, excuse me, here's our covenants, our bylaws, articles of incorporations, owners association statement, title insurance policies, deeds, da-da-da-da-da. So seller is going to provide us with that. This is just talking about the seller. They're going to have to release their title insurance policy when they sell. So this is discussing that, how the attorney handles that, gets involved in that. Seller agrees to provide the buyer a general warranty deed. See this same verbiage, free of fee simple marketable title, legal access, public right of way, free of all encumbrances. Here's our utility easements. Again, this exact paragraph is copy and paste in our contract, so the buyer knows what they're getting. As the seller recently had a home inspection, pre-listing inspections are gaining in popularity. They're not as intense, as in-depth, I should say, as a buyer's home inspection. But it does allow the home inspector to go through real quick, notice if anything stands out to them. Still doesn't obligate the seller to do repairs. They don't have to if they don't want to. But at least if they do this pre-home inspection or pre-listing inspection, they're not going to be surprised when the buyer has their home inspection. They can kind of be prepared, have discussions on how they may handle repair requests if they choose to. Photographs and other materials. The pictures that I take of your home are my firm's. They're ours. And that's what we're saying here, is that that's our property. They may pick pictures of your home, but that's our property. If you're going to list a home after another firm, has it expired? Make sure you do your own pictures. Do your own work. Don't copy. That's called stealing. So make sure you do your own work, understanding that those pictures are ours. Additional terms and conditions. These are things that the firm and the seller agree to that maybe we just don't have a place to hear. For example, one thing I've heard agents use this field for, sometimes we get a rather unrealistic seller. They think they're going to sell their house for more than what we think they can sell their house for. So maybe we start with, you know, we'll list it for X amount for the first 2 weeks. And if we don't have an offer in 2 weeks, we're going to drop it to X amount, right? So whatever that, however that's going to work, I've heard of that being used for additional terms and conditions. Again, just something seller and firm agree to. And then we get into dual agency as it's explained to the seller. So the seller understands that a potential for dual agency will arise if a buyer has an agency relationship with the firm, becomes interested in viewing the property. You guys see that? It doesn't say buying it. It says we got to get permission to get them in the front door. We got to get permission to allow the showing. I do think, you guys, this is like another good place to review. Again, we'll talk about dual agency, but I think this is a good place because, again, it's dual agency as it's explained to the seller. So we can use this to help us have this conversation. I just backed up by the words. So disclosure of information, what's the firm's role when they act as a dual agent? What does that mean for the seller? It does a really nice job of breaking it down. Is designated a designated dual agency an option? First off, the firm has to offer it. And if the firm does offer it, is it something that we can offer the seller? And then we have authorization for dual agency. And again, this was a big change they made to our forms last year, which is so much easier to see, so much better to explain. So we're told to initial dual agency or exclusive representation. So it's either dual agency, seller authorizes the firm to act as a dual agent representing both buyer and seller, or seller wants exclusive representation and does not authorize dual agency. So when we see this, the first little flag that goes up for us is, do you want to do dual or not? Do you want to do dual agency and share with the buyer, or do you want exclusive representation? If they say yes to dual, then we need to find out if they're okay with the same agent acting as a dual agent. Are they okay with single agent dual agency? And if we have a yes to dual, if the firm offers designated, then this is where we get permission to offer, to offer designated. We're going to see very similar verbiage in our buyer's agency agreement. Comments on that? Any good contract has remedies for breach. So what happens if we terminate? What happens if we breach? If at all possible, we want to try to hash this out in mediation instead of going to court. Attorney's fees. Wire fraud. This is something that's gotten really big, really fast in real estate. And we got to protect our clients, you guys, because they are very trusting of us. And what's happening with wire fraud is hackers are getting into our emails, and then hackers are sending emails that look like they're from us. And they're telling the sellers, for example, and the buyers, where, especially the buyers, the wire transfer instructions for the attorney. But the problem is the hackers aren't giving them wire transfer instructions for the attorney. They're giving them wire transfer instructions for their offshore overseas account. And as soon as that money hits, that thing closes down. And generally, once that money's gone, it's gone. I heard of a case in Winston-Salem just a couple weeks ago. An elderly couple received an email with wire transfer instructions. They wire transferred $130,000. It's gone. It's gone. That's their retirement. That's their life savings. And it's gone in literally the click of a button. Fortunately, the agent's E&O insurance kicked in. Unfortunately, the agent's premium went up. So I think they did get their money back. Did that hurt? That hurts me. It makes me a little sick to my stomach to think about how that can happen. But you think about some of these price tags on houses, the money that's changing hands. So bottom line, the best thing we can do to protect our clients when it comes to wire fraud is look them in the eyeball and say, I will never email you wire transfer instructions. Never, ever, ever. Because they need to know if they get an email from you, it's not from you. Thoughts on that? It's tough. You know, the Real Estate Commission is doing a wire fraud seminar this year. They're going to several different locations across the state. I was fortunate enough to do the wire fraud seminar back in 2019, and it was really good. They had the FBI, they had somebody from the title insurance company, they had attorneys there. It was good. I mean, y'all, the FBI stood there and looked at us and said, hackers are 2 steps ahead of us. About the time we figure out what they're doing, they've moved on to the next. What this says down here, we need to tell, again, for the sellers, this is going to apply when they want their proceeds wired to them after closing. You know, the buyers are sending their money to the attorney's sending the money to the sellers after closing. If that's what they want to do, we just need to encourage the seller to go old school, pick up the phone and call the attorney's office to get that wire transfer instruction. That's not something you and I need to get involved in. Let the seller or the buyer communicate directly with the attorney. And by the way, either you provide them with the attorney's phone number or they look it up. Don't let them call on a number that they got in the email. Because what if that email was hacked and they're calling the hackers? So have them look it up independently or you provide it to them, but don't tell them to rely on emails. You guys have 2-step verification or authentication turned on your emails. You may want to if you don't. I mean, it's kind of a pain in the butt, I know, because every time it asks you for your, because it's got to text or email you a code, and sure enough, you won't have your phone in front of you, so you got to get up and walk to another room and get it, or you know. But seriously, it's just another layer of protection for your email. Anybody have encrypted email? And if you have an encrypted email, Teresa, yeah, I don't know, maybe coming soon to real estate. That might be something we're looking at next, is encrypted emails. I don't know. We got to get ahead of this somehow, though.
The only way to do it is to rewind time and go back to the old Linux systems.
Yeah. You know, the fax is coming back in the medical field because it's a lot more secure than email. So maybe that's what we do, is bring the fax back. You know, I don't know. I don't know. You know, the other thing they talked to us about in that wire fraud seminar that I think's worth bringing up, sometimes we like to, I don't know about you guys, but sometimes I like to go take my laptop, work at a coffee shop or Panera Bread or something like that. If you're going to work on any of your clients' sensitive information, do not get on the public Wi-Fi. Do y'all know who can access the public Wi-Fi? The public. So if you want to go work in a public place, y'all get on your mobile hotspot. Keep that secure. The FBI, again, at the wire fraud seminar, shared a video with us, and it was a young lady that went to Panera Bread. She didn't look like a hacker. She wasn't wearing her I'm a hacker t-shirt. She went to Panera Bread with her laptop. She got herself a coffee, and she set up a fake Wi-Fi called Panera Bread 2.
Wow.
And within minutes, people from all over Panera Bread were hopping on it. She was sitting right next to you, just taking your information. It's wild. Y'all be careful out there. Absolutely. Other thoughts on that? That's a deep, I kind of hate to end on this. We're not ending just yet, but we got to think. They're smart. We got to think. It's all the scams out there too. It's all the scams out there too. You got to think when you answer your phone and your door these days, don't you? So just be careful. Okay, so then we have the place for everybody to sign. So I got a place for 2 sellers. Each seller, we're going to print the name, signature, and the date. We're going to look for their contact information and mailing address. I need all the sellers that need to sign the deed to convey. I need all of them on board on day 1 to sign the listing agreement. So all the sellers that are on the deed and their spouses have all got to be agreement on day 1 to sign this listing agreement. If you have one person that's not willing to sign, you got to ask yourself, what happens when we get to the closing table and they say, yeah, no, I'm not signing that. if you have more than 2 sellers, we have an additional signatures addendum. The additional signatures addendum gives us a place for 8 more sellers to sign. So now we have 10 sellers. If you have more than 10 sellers, you use another additional signatures addendum. You use as many of those things as you can, as you need to get all the sellers and their spouses on agreement on day 1. So we're all on the same page. If your seller is an entity, they're an LLC or a corporation, we're going to list that information. We have one person, where are they? Yeah, one person that's allowed to sign on behalf of the entity. So they'll be the ones probably you're communicating with. And then the firm. So we print the name of the firm's license number, and then it's the individual agent that signs it. So it's signed by on behalf of the firm. And there's one of our musts where you have your individual license number. Questions? Comments? Have you guys looked through this yet? Couple of you. Before you go to that listing appointment, obviously you're going to want to be familiar with it, be knowledgeable with it. I'm just such a believer in the forms. And you know, before I started teaching, I made it a point, my mantra, whenever they updated the form, whenever they released a new form, NCAR is really good about sending us, they call it a markup. So they tell us exactly what changed. So they show us what they added, what they deleted, right? So they show us that instead of making us do like a side-by-side comparison, they actually show us the changes. So I think the markup's helpful so we can see those changes. When I was in sales, I made it a point that when they changed the forms, that was my opportunity to sit down to read them and review them so I could be familiar with them. Guys, the deal is if we scroll through this, you know, my job is to fill in the blanks, right? And as we scroll through, there's only a few blanks, isn't there? And I think sometimes we get busy and we only care about the blanks because that's our job, but there's so many other things in here that's important. And that's why I think it's important that we are familiar with this and we go through it and we review it periodically. The offer to purchase and contract, buyer's agency agreements, whatever you're going to use regularly. This is your tool. Use the forms to your advantage. What else? What do we think? So tomorrow, we're going to be working with sellers most of tomorrow night. We got a big section of working with sellers. So we probably won't get through sellers tomorrow. So we know we'll have that to look forward to the start of next week. One big thing we're going to do tomorrow, if I have to skip around, I will. But one big thing we're going to do tomorrow, remember you guys have 2 mandatory homework assignments. So before we leave tomorrow, we're going to go over both of those sections. We're going to give those assignments. So then that way you guys have the week to do them. They've got to be complete before you take that exam next Thursday night. So I will, like I said, I'll rearrange the order of the class if I have to. But I think it's important that we go over that. So you guys have the week. Is that fair? That give you? Okay, good. So we'll talk about that tomorrow night. But we're in really good shape. So that's what I know for tonight. Have a good night. Enjoy the rest of your night, what's left of it, right? And we'll catch you guys tomorrow night. Michael's going to bed. Good night.
All right. Thanks.
Good night.
All right. Good night.
Bye, y'all.
See you later, guys.